Hi, this is Lindsay Oden, Special Research Assistant at the Washington State Attorney General's Office, and this is your AGO Moment in History. In this series, our office will be releasing clips from our Oral History Project, an ongoing effort to collect and preserve the history of the Attorney General's Office as told by the people who have worked here over the years. In this episode, former Deputy AGs Jeff Goltz and Shirley Battan interview former Attorney General and Governor Gregoire. Gregoire served 3 terms as Washington State's Attorney General from 1993 to 2005. In this clip, Governor Gregoire describes her experiences arguing at the U.S. Supreme Court. She argued 3 times: Brockett v. Spokane Arcades, Inc. in 1985, Public Utility District No. 1 of Jefferson County v. Washington Department of Ecology in 1994, and Washington State Department of Health and Human Services v. Guardianship Estate of Keffler in 2002. Gregoire says that these arguments were some of the highlights of her career. Let's take a listen.
So another high point, I assume, in your career in the AG's office, both as a deputy and as an Attorney General, was arguing in the U.S. Supreme Court. Last Friday, I interviewed Herb Fuller, who was Chief Assistant Deputy under Attorney General O'Connell, and he argued twice in the U.S. Supreme Court, and he described it as like pitching in the World Series. So I was wondering if you had a baseball metaphor you wanted to use, or some other description of that experience.
Pitching in the World Series. Well, okay.
You can scrap that.
It's an amazing experience.
Yeah.
Let me just say that. It's an amazing experience. And best described this way. I took one daughter to one of the arguments. Both daughters got to go to an argument, as did my mom. But anyway, one daughter. And I remember sitting there and saying to myself, as I watched Justice, we were on deck. The case before us, Justice Scalia was taking a member of the Solicitor General's office, U.S. Solicitor General's office, who argued numerous times, and ripping him to shreds, just destroying this guy. And me sitting there saying, I am an office of 400 and some odd lawyers. I could have assigned this case to how many other people? But oh no, I can take this case. Scotty, beam me up. I don't know why I've done this to myself, and so on and so forth. And just, Anyway, get up, argue the case, get done, go outside, bright sunshine, and my daughter turns to me and says, well, how do you feel, Mom? And I remember throwing my arms out at the top of those steps and saying, I love being Attorney General and arguing before the U.S. Supreme Court. So I don't know if that's like pitching in the World Series, but you go from, oh my God, I wished I wasn't here, beam me up, Scotty, to this is the highlight of my life. I mean, it's just...
So do you recall, was that the first case, the Spokane Arcade case?
No.
Or the
my kids were too little. That was the Elkhorn case.
Yeah, which was a water pollution
case.
Yeah.
Yes.
And then you also argued DSHS versus Keffler.
Yes, and I want to talk about why that's unique.
Tell us why that's unique.
Washington State Supreme Court, 9-0, we lost.
Yeah.
U.S. Supreme Court, 9-0, we won. I come home, several justices call and say, can you not embarrass us like this again?
Did they really talk to you? Yes.
And I said, I think it's you guys, not me.
Do you want to describe just briefly what the underlying issue was?
Oh, this had to do with foster care payments and kids with special needs, and whether we were paying appropriately extra for them and so on and so forth. And, I felt great about the argument, I have to admit. But who would have ever thought it would be 9-0 reversal of a state Supreme Court?
So tell us a little bit about, your predecessors, Ken Eikenberry, but especially Slade Gorton, argued many cases before the U.S. Supreme Court. And you argued several, but other people in the office argued a number of them too, Bill Collins, Bill Williams, and others. Kathy Mix. So how did you decide which ones you would argue and which ones you would leave to others?
So arguing before the U.S. Supreme Court, and I would say this to any Attorney General, is your prerogative. If you want the case, it's yours. If for whatever reason you don't want it, or you want to have another person in the office argue it, it's yours to give. But you have the right to argue a U.S. Supreme Court case. So I felt very close because of the environmental nature on the Elkhorn case. The first case, I just got assigned from Olympia when I was over in Spokane. It was a challenge to a new statute that we put in place, had to do with obscenity law, First Amendment obscenity law, of all things.
Spokane Arcade.
Yes.
Yeah.
So I got the case over there, won the case in federal court over there, went to the Ninth Circuit. So I just kept the case. As a deputy, I ended up going. Having been the head of all the environmental divisions, I felt near and dear. And the Elkhorn case was really quite unique. I just have come back from teaching at Harvard last fall. I was asked to teach a class on that case. And what I discovered was, I didn't realize this, you can go back after a certain period of time has elapsed into the archives in the U.S. Supreme Court, and you can get things like, I know what the vote was inside to take it. I have a grade that I was given by one of the justices. Oh, yeah.
Oh, wow.
I have his notes, and so on and so forth. And it was a very complex case, to be perfectly honest with you. And this professor at Harvard said it's one of the more complex cases, and it was. I love complex things, and so it was a thrill for me. DSHS took me back to my roots. I wanted, that case, and I felt we had been wronged, to be perfectly honest with you, in the state Supreme Court. I thought they had just got it dead wrong. And I was a little bit determined to show that the state of Washington was doing it right, was a model for the rest of the country, and here we were going to be? No. So
what was the preparation like? As I recall, was the office preparation for a U.S. Supreme Court argument different from when you first argued in the Spokane Arcade case to later on? I think that's a yes.
In the Spokane Arcade case, I think it was Phil. Was it Phil?
Phil Austin.
Austin. And who else was it?
Tim Malone.
And Tim. And it was Tim. Talking with me. Chatting with me. Just standing in a room like this where Tim would go around with his pipe and Phil would say something, and that was my preparation. Now go back there. And good luck to you.
And you went back by yourself?
And I went back by myself.
Okay.
Yes.
Wow.
Wow is the right word.
But then you left the office for a while, came back, and now you're Attorney General, and you have the Elkhorn case. How
rigorous.
How
I spent weekends. Jay Manning was the head of the division at the time.
And Jay argued it in the state Supreme Court.
Right, and he knew the case well. He was with me often. He was panicked that I wasn't going to spend enough time because he knew how complex it was. So I didn't have time Monday to Friday, so I spent weekends, a lot of them, in preparation, was intimately involved in the brief filings, and so on and so forth. Then went back early and spent days, went about as vertical as you can get. There wasn't a fact I didn't know. That's my theory of what you have to do back there. Did my moot court experiences back there, had some moot court experiences back here, did them back there, though, and then took the last afternoon off to just clear the head. I think we went to a movie. It was a really dumb movie. But anyway, went to a movie just to do something mindless, and got up the next day and went in and did it. And that's how you have to do them. You have to have, they have to have your undivided attention. And there is no fact that you can say, well, I don't remember, I don't know. You have to have it all. You need to know what page it's on. And reminding me from Harvard this last fall, very specifically, the court said, what page will I find that? And I have no idea how I knew it, but I answered it right up. And that's just how well you have to know them. And if you go back there with an attitude that you can get by or whatever, it won't work.
Thanks for listening to this AGO moment in history. Be sure to like and subscribe to receive updates when we upload a new episode. On our next episode, Governor Gregoire talks about the AGO's relationship with other parts of the state government, especially the governor's office. Thanks, and talk to you again soon.